crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Hello and welcome into the attorneys. Thanks so much for being with us tonight. Got a really interesting topic of conversation, an incredible panel to discuss it. First, though, some ground rules. We'd love to be a part of the conversation all throughout the show tonight. You'll find ways at the bottom of the screen where you can call, text, email, and get in touch with us. Would love to have you once again be a part of this show. So if you have a question for us, we'd love to hear it. Also, Hollis Wright does a really neat thing every time we're on the air, and that is they make their attorneys available live for you. It's a free, off-air, and confidential conversation. So during the program tonight, if a question pops into your mind and you want to speak with an actual attorney from Hollis Wright, you have the opportunity to do so. So if a need arises, please take advantage of that throughout the program tonight. Carter Clay is leading our conversation. Good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing well, and looking forward to this topic of conversation. There's a lot of ground to cover.
Well,
here.
and it impacts a lot of people out there. Yeah. So we're going to be talking about landlord-tenant laws, primarily, if not exclusively, in the residential context. Okay. Obviously, as people probably know, you could have a landlord-tenant in a commercial context with a commercial office space building, but we're primarily going to be focused on the residential setting here tonight. And when I talk about it impacting a lot of people out there, I'm not kidding, because a lot of people out there, especially since the housing crisis in 08, 09, have gone the route of renting a condominium, an apartment, or a house, as opposed to buying a house because of the restrictions and new laws related to getting a mortgage and things of that nature. Statistics show right now in Alabama that about 1 out of every 5 renters of residential properties is behind in their rent.
Oh, wow.
And so that is a big issue that people in Alabama are confronting, and we want to address the rights and responsibilities of the landlord, and also the rights and responsibilities that a tenant would have when they enter into a lease agreement with the landlord, and what they can and cannot do on both ends of the spectrum to try and help landlords and tenants navigate disputes that they may have with one another. I mean, we'd obviously all like to go into a landlord-tenant agreement and not have disputes, but invariably disputes are going to arise, and I cannot think of a better person to help us tackle this topic than James O'Connell. James is an attorney here in the Birmingham area, and he's got one of the more unique, creative domain names for his website, which is the probateprofessor.com. So obviously you've got a background in estate and probate work, but obviously I think one of your big areas of practice is landlord-tenant law. So James, first of all, thank you for being here this evening.
Thank you. It's good to see you, Clay.
Yeah.
Appreciate being here.
Yeah. Tell us a little bit about your legal practice and how you got involved in handling, I guess, landlord-tenant disputes and issues arising from rental agreements.
Well, it sort of came about in 2 ways, Carter. I have done a lot of probate work primarily in my practice, and at the same time that I do a lot of this probate work, a lot of landlord-tenant issues would arise in that context where a client would have rental properties or something like that. And so I branched off a little bit into doing some landlord-tenant work, and I also did some landlord-tenant work because my family has several properties and apartments and buildings and things of that nature. And so I learned from doing some of that work, and I also found there's a lot of need for this kind of work, and so I've taken on quite a bit of it. It's a significant amount of my practice these days.
Yeah. Is there a particular statute in Alabama that kind of governs the rights and responsibilities of landlord-tenant relationships?
Yes, there's 2 sections of the code, or I should say 2 chapters of the code within Title 35. There's Chapter 9, which covers generally landlord-tenant and all of your commercial landlord-tenant relationships. And then we also have under Title 35 at Chapter 9A, Alabama has adopted the Uniform Residential Landlord-Tenant Act, which conforms to the majority of states. So our law is similar to the majority of states in that regard.
Yeah. And I guess by law, do people have to have a written agreement to rent an apartment or a house or a condominium, I guess we kind of take for granted that almost, I guess 99% of them probably have some written agreement. Is that required under Alabama law?
But no, it's not required. I would say, in my experience, it's closer to about 90%.
Okay.
There's a fair number that do not have a written agreement, or the written agreement is so old that nobody remembers where it is, what it said, or anything of that nature. But if there is a written agreement, then the written agreement is enforceable under contract law as any other contract would be, except with a few limitations of things that you cannot put in that contract.
Can you tell us what those few items are that you generally cannot put into a lease agreement?
There's a few things that come up a lot. I'll say that the most important things that come up. One is that you cannot charge a security deposit that is in excess of 1 month's rent. And that is exclusive of landlords can charge a pet deposit and or a pet fee that can be in addition to or beyond and above that 1 month's rent. There are requirements about what you can force the tenant to pay for in terms of maintenance and repairs and things like that. That's very limited.
So I guess it's not a coincidence, because I've rented properties not recently, but back when I was, I guess, college age and in law school, and they'd always charge you that 1 month for security deposit, and there's actually a law behind that. It's not just a coincidence that they have that, because they cannot charge more than that for a security deposit.
That's correct. Right. And if there is no written agreement, then the rent is simply the fair market rent, and the term is month to month if rent is paid monthly, or week to week if the rent is paid weekly.
So when an individual is interested in renting a house or renting an apartment, and they are presented with a rental agreement by the landlord, what are some of the big ticket items that you would advise or recommend that the tenant take a look at to make sure that they are getting what they expect to get?
Well, certainly you want to read all of the contract, and I know that we all do the click through, right, and just sign at the bottom sort of thing, but it really is important to make sure that you're looking at these contracts, and the most important terms that typically are on the first page, things like what is the rent, when is the rent due, what is the late fee, what is the term of the lease. And one of the things that's often not in the lease itself, but merely is incorporated into the lease by reference, is the landlord's rules and regulations. A lot of times they don't put that into the lease, and sometimes they don't even give it to you before you move in. But when you sign a document that says that you've reviewed it and it's incorporated into that contract, you are bound by it.
Right.
And so you need to make sure that you are aware of the landlord's rules.
Yeah, and David, that's an excellent point, because we all have a tendency, whether we're buying a car, whether we're renting an apartment, where somebody presents you with an agreement that's 2 or 3 or 4 pages long with a lot of legal terms in there, and what do? We just initial here, sign here. We just have a habit of not even reading through it. But there are a lot of pitfalls and dangers in not closely reviewing or reading any agreement, not just within the context of landlord-tenant, but any agreement, and not so much because you're going to be able to change the agreement. Right. And James could speak to this, but most of the terms in the agreement, they're not going to negotiate over. They're not going to cross stuff out and change it with you. But it's important to read it to understand what your rights are and what your responsibilities are, so that you're complying with the agreement and you're not running afoul of any of those provisions. Because if you read and understand it and ask questions to make sure you understand it, it's much less likely that you will get into a dispute with the landlord. Yeah,
no one likes being blindsided, especially whenever you have a problem and then they say, well, it's in the lease that you signed.
Section J, right. 2I.
Yeah, they signed it. All right, let's take our first break of the evening. Interesting topic of conversation tonight. Looking forward to this. Would love to have you be a part of the conversation. Also, a reminder as we head to break, Hollis Wright is all over social media. So wherever you are, they are. Just search the term Hollis Wright and you'll find them. They're a great resource for you to keep up with what's going on legal matters for sure. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with The Attorneys.
Welcome back into The Attorneys. Before we head back to the conversation here with our panel of experts, a reminder, attorneys from Hollis Wright are standing by. So for the remainder of the show, they're standing by live to speak with you. That free, off-air, and confidential conversation, a great opportunity for you. All right, a question we've got here from someone who is currently apartment shopping. And what advice can you give me prior to signing a lease?
Well, the most important thing is to read that lease and know what it says. And make sure that the terms that are in the lease are in fact what you've agreed to. If you have any agreement with the landlord, it needs to be in the lease. There's typically some blank lines somewhere towards the bottom of the lease where you can add certain language if it needs to be added. And you need to make sure it's there. If you have any agreement with the landlord, it needs to be in the lease. It's amazing how often people forget the things that they promised to do when it's no longer in their favor to do so. So make sure that whatever you've agreed is in the lease, and that also you have reviewed the rules that the landlord has. Whatever those are, if they're incorporated into the leases, they always are. Make sure you know what they are.
Have you seen numerous examples over the years where it was not contained in the lease agreement, but outside the four corners of the agreement, the tenant was saying, well, they told me before I signed the agreement that they were going to do X, Y, and Z. Is that something that happens quite a bit?
Absolutely, it happens all the time. And the other one that comes up all the time is, well, I told the landlord I was moving out, or I told the landlord I was going to be on vacation for the month of June, things like that. If you tell the landlord anything, make sure that you put it in writing. Send them a letter, send them an email, send them a text. Make sure it's in writing, because it's just one of those things that they forget.
Yeah.
When it's no longer convenient.
That's right. So let's assume the lease agreement has been signed, a contract has been entered into between the landlord and tenant, and it's close to move-in date, and the tenant goes over to check out the apartment. What are some of the things that you would advise or recommend that a tenant and perhaps even with the landlord should do? Should they do some type of walkthrough inspection before they actually move in and check to make sure that things are working? Talk a little bit about that.
Yeah, absolutely. I would say on that point that the number one thing is to make sure that you're looking at the unit that you are actually moving into. I have taken several cases where the landlord said, here, this is our model unit, just come in, take a look. The other unit, it's identical. It's just the same thing. Just look at this unit, you'll see all the same things. And they move in and it's not at all what they expected. Or it's infested with bugs, or it's damage to the walls that, of course, isn't documented, and then the landlord wants them to pay for it. Oh, we won't charge you for that later, it's okay. So make sure that number one, you're looking at the unit that you are going to rent, and number two, document everything that's wrong. So check everything. If you see damage on a wall and the landlord says, oh, that's no big deal, just take a picture, mark it down, mark it on the move-in sheet. Most landlords give you a move-in sheet. Make sure you get a copy of that move-in sheet that shows all of the things that you and the landlord have agreed were already damaged when you got there. That's another document that, for whatever reason, tends to conveniently disappear when I make a discovery request. I don't know how that keeps happening, but make sure you get a copy and keep a copy of that. I also have tenants say, oh yeah, you know, I had that, I just don't know what I did with it. So keep these documents, they really are important.
Yeah, and I know it may seem like overkill, but do you recommend that they go in and turn on the air conditioning, flush the toilets, turn on the water? I mean, is that something that you would reasonably expect a tenant to need to do in those types of circumstances?
It's a good idea. I don't see so much somebody reporting something the day or two after or a week after they move in that, gee, the hot water's not working, that the landlord says, well, you broke it. Right. That's not something I see as much as where there'll be, say, a door missing to the laundry room, and the landlord says, oh yeah, I just didn't bother to replace it, but then when you move out, somehow they forgot that they said, oh yeah, I never replaced it from the last tenant, and they charge you for it.
Yeah. Talk a little bit about the landlord's responsibilities. Like what are the legal requirements of the landlord in terms of the basic things that they have to provide a person when they're renting an apartment or house?
Well, if they're renting a living space, a residential living space, then they've got to provide a habitable living space. And there's not a whole lot that's required there. Heating, ventilation, air conditioning, as you said, hot and cold water. And if they provide appliances, then they have to maintain and repair them. But other than that, there's not much that the landlord is required to do other than to not burden you and to provide you with the quiet enjoyment.
So if they provide you with a habitable or livable space, what happens during the term of the lease agreement if, say, the air conditioning goes out or the plumbing is bad? Who has the responsibility to make those repairs? And if it's the landlord, talk a little bit about what the tenant should do to apprise or notify the landlord of these problems and make a request to have them repaired.
So commonly what landlords do is they'll have a portal, as they call it, where you will enter the information that you need something repaired, and then it will go to maintenance to be repaired. What I suggest tenants do is when you enter that into the portal, either at the time you're entering it or after you enter it, when you get a maintenance ticket or something like that, take a picture of that, print it out, whatever you have to do. Make sure you can document the day that you reported it and what you reported, because this comes up a lot, where I'll come in and say that the toilet hasn't been functioning for 6 months, and the landlord knew about it. The landlord says, well, we have one ticket and it was from last week.
Yeah.
And we never heard anything about it before.
Now, James, you made reference to a portal, and if my father was watching the show right now, he would not know what you meant by a portal. Are you talking about something on perhaps a website that the apartment complex or the landlord might have to where you can go in and put this in a computer system of some kind?
That is the typical system here in 2021, is that most of these landlords have on their website what they call a resident portal, and the tenant will enter into this portal, enter their name and their unit number and then their maintenance request. But what happens with these things is we don't know what happens after it goes into the portal.
It just may go into a black hole, never to be seen again.
And sometimes as I said, the tenant will say, yeah, I've reported it 3 or 4 times over the last 3 or 4 months. The landlord says, I only see one from last week. Yeah. And so those kinds of issues come up a lot. If we can't prove that it happened on a certain date.
Yeah. So maybe it's a good idea to follow up with an email. Put it in the portal, but if you've got an email to the landlord, send them an email just to confirm what you put in the portal, right?
Yeah, that's it. All right, time for us to step aside. This is our final break of the night. Time's flying on this show, isn't it? Not much left, so if you want to join the conversation, just a few minutes to do so. Stay with us. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 4-in-1, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? First, do your research. Look the firm up on the internet. Learn about the cases they handle and the results they get. Second, find out what clients are saying about the firm. Many websites provide client testimonials or have a star ranking system. Use those to your advantage. And finally, talk with a lawyer from their office and ask them questions. Questions about the volume of cases they handle. Do they return phone calls? Are you just a number or a client that gets the attention you deserve? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on WVTM 30.
Well, time is flying, and tonight's episode for sure, almost out of time, about 6.5 minutes remaining. So if you want to take advantage of the opportunity to speak with attorneys from Hollis Wright, you've got about 6 minutes to do so. Back to questions. We've got a good one we've got here. Someone says, my lease is ending soon. So the request to you is, what do I need to do?
Well, when your lease is ending and you're getting ready to move out, make sure that when you are done moving out, that you do a couple of things. One, take pictures of every room, every area, or videos. Videos are great too, and show that you have done a thorough cleaning and that you have emptied the unit. Those are the two big things that we get hung up on quite frequently on these move-outs. And the other thing you need to make sure you do is you need to give, again, in writing, we've got to document that you did this, give a forwarding address when you leave. And the critical importance of providing that forwarding address to the landlord is that the landlord then has 60 days after you vacate the premises to either return your security deposit or to provide you a list of items that are being deducted from your security deposit for damage that you caused. We can dispute those items if you've got photos, videos, and things to show that you did not cause that damage. But if you don't have that, you're in real trouble.
What other factors, because I've seen this happen before, and really from personal experience going back in time, is a lot of these lease agreements tend to have a provision in there, let's say it's a 12-month lease, that you have to notify them either 30 or 60 days before the lease is set to terminate that you are not going to renew the lease. And if you don't comply with that provision, then it automatically renews on a month-to-month basis. And David, I've seen circumstances, again, where people perhaps didn't go back and look at their lease agreement as they got towards the tail end of their lease term. Right. And all of a sudden they're thinking they're moving out because their lease is expiring in 10 days, and all of a sudden they look at it and say, well, I was supposed to notify the landlord 50 days ago that I was not going to renew. Yeah. And then the landlord is like, well, it's renewed on a month-to-month basis. Is that something that you see from time to time?
Absolutely, that is. And that, again, is we've got to give written notice to the landlord that you are leaving at the end of the lease term. This is particularly important, too, in the military context, because there is a federal law that says that officers of and enlisted members of the military service can break a lease if they are deployed. However, because I just had this case, you must give written notice. And if we cannot show that you gave written notice, we're in trouble. And we are in real trouble. This gentleman was deployed and served for us in Afghanistan, and his landlord's breaking him over the coals because he didn't give written notice, even though he gave oral notice. He even showed them his orders, but they forgot.
Yeah. Oh, wow. All right. talk a little bit about if a dispute arises with the landlord. Maybe the tenant, there's something broken in the apartment and the tenant says they need to get it fixed, and they ask the landlord doesn't fix it. We can use that as an example, but there are many examples. Talk a little bit about what a tenant should or should not do, because I think impulsively a lot of times tenants think, well, if you don't fix this, I'm just not going to pay my rent for this month until you fix it. Is that a no-no?
Yeah, that's exactly right. That comes up all the time. That's the most frequent question that I get. And so what I tell tenants is, first of all, the law is explicitly clear that if you do not pay the rent, you cannot enforce any of your rights. So that is absolutely a no-no. If the landlord is not fixing something that you think should be fixed, and perhaps the law requires them to fix, the practical reality is your good choice is to simply move out and do it properly. We've got to give the proper notice and make sure. I do these letters for tenants several times a week, where I give the landlord proper notice under the law, and then we give them 60 days to return you or any prepaid rent that you have, any security deposit that you have, and if they don't, then we assume we get double the security deposit back. And any prepaid rent. That is to say that you paid the January rent, and I give them a letter and say you're leaving on January 20th, they owe you 1/3 of the rent back plus your security deposit.
Wow. Believe it or not,
yeah,
we're almost out of time. Just a couple of minutes remaining. I want to give both of you opportunity for a final thought, and if you would, you go first, please, sir.
Excellent. Well, this is something that I've done quite a bit of. If I can help you, please do give me a call. The fine attorneys at Hollis Wright can help with that, and they can certainly help you with your personal injury matters as well, and we're glad to be here and glad to serve the community.
Yeah, David, I would take on one issue, or just address one issue that we didn't quite get to cover, but I think it's important for the landlords to understand this is that if a tenant decides to walk out of the apartment on, say, month 8, and they had a 12-month lease, so they just leave the property, they vacate the property, the impulse reaction by the landlord would be is, well, you owe me 4 months worth of rent because you breached the agreement early. Right. And while that technically is true, the landlord also has a responsibility under the law to mitigate their damages. And what that means is the landlord has a responsibility to at least make a reasonable effort to try and find a new tenant for that very same apartment, because the apartment is now vacant.
Right.
And so if the landlord does not make that reasonable effort and the tenant challenges them on it, it could present some problems for the landlord in terms of collecting all of that remaining rent. So that's just a little bit of advice out there for the landlords. Don't just sit back and think, well, I'm just going to collect 4, 5, 6 months from you. So
yeah. Good advice, and tonight's been full of good advice. Appreciate you being with us tonight. Thanks so much.
Thanks so much, James.
And Carter, good to see you. As always, we'll look forward to seeing you next time, and you as well. As we always say, thanks so much for joining us. And don't forget, ways you can contact us if you would like to. Find Hollis Wright on social media. A great place if there's anything, and including this show, and ways to contact our guests, all available on social media. Thanks so much. See you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.